Yes, sir.
And do you recall, and Dar is the trustee of that trust, correct?
As of 2015, yes, sir.
As of 2015, is Dar no longer the trustee of that trust?
I'm sorry, you asked me if Dar was the trustee of that trust.
Yes. Oh, you're saying as of 2015, he began as a trustee.
Yes, sir.
I'm sorry, I thought you meant as of 2015, then he was no longer trustee. I apologize. So he is currently the trustee of the trust.
Yes, sir.
Okay. And of the 4 trusts that you have reviewed, that's the only one that he's a trustee of.
Yes, sir.
Okay. And then I think that we had an opportunity to look at page 9 and in particular paragraph E. And we reviewed that for a couple of reasons, but one was to determine whether or not there was a diversification excuse provision in there. In other words, something that says no requirement to diversify the trust. Do you recall that testimony?
Yes, sir.
Okay. And just to confirm, you reviewed it and there was no a diversification excuse provision. What would you call that?
Diversification excuse provision?
Like you're excused from having to diversify the trust.
Well, the trust lays out in its 4 corners the mandate to the trustee. So it's the originating document. It would allow for retention of assets. It would provide mandates for direction over investments. So is that what you're asking, sir?
Yes, and I'm asking you is there a diversification provision in here? Provision related to diversification, excused from having to diversify? There wasn't one in there. I think you saw that yesterday.
Well, I believe we did review it, paragraph E. So there is a mandate regarding investments. Is that where we are? Page 9?
Page 9, paragraph
Paragraph E.
E. There's a mandate regarding investment. Yes.
Okay.
And I'm asking you, is there any provision in E or any other part of the trust agreement that would excuse the requirement to diversify the assets?
Other than what's in E?
Point to me in E what it said, where there's a provision that expressly states that the trustee is not required to diversify the assets.
The first sentence, the trust estate solely in direct obligations of the United States government. I'm not sure what you're asking, sir.
Well, you're an expert, correct?
Yes.
And you're familiar with provisions related to diversification, correct?
Yes.
And you're related to that you're familiar with provisions that say shall not diversify the trust or may not or is not required to diversify the trust. You're familiar with those sorts of provisions.
That's one way for it to be written. Yes, sir.
Well, point out to me where there's a provision in here that expressly relates to diversification.
I'll try and answer again. Paragraph E.
Okay.
Solely in direct obligations of the United States government and continuing forth.
Yes, and I'm just trying to get this clear. You think that that is a non-diversification provision?
Absolutely.
You believe that paragraph E would allow the trustee to invest 100% in Exxon stock?
No, sir.
Okay, well, why not? I asked you if there was a diversification provision that would excuse the trustee from having to look to Texas law and diversify the trust. And you said, yes, there was. And I'm asking you now, where is that provision that would allow the trustee to be excused from diversification?
I still remain confused by your question because I'm going to provide the same answer. Paragraph E directs the trustee to invest solely in, and then the remainder of that paragraph.
And that's your understanding of a diversification provision?
What is a diversification provision? Maybe that's where the confusion is. I'm not sure what a diversification provision is then.
Okay, that's fair. Thank you. If you're the expert to be called on issues related to investments and you're not familiar with the diversification provision, that's all I need to know.
Your Honor, I'm going to object. That's a statement in sidebar. I think the witness has answered the question. If Mr. Cook wants to frame it differently so it could be answered, but otherwise I move to.
And that's fair. I apologize. So it's fair to say that you do not know what a diversification provision is?
No, that's not fair to say.
Okay.
Are you asking about a provision within the trust agreement? That's where you referenced me, Mr. Cook. I'm on page 9.
Yeah,
It is paragraph E. Is
Okay.
this what you're saying is a diversification provision?
no, I asked you to point out the diversification provision.
And I've answered that. In
Okay.
paragraph E,
Hmm.
in paragraph E, there is a mandate and a direction for how the trustee would invest. Shall, required, mandate. Is that what you're asking me? I'm just not sure, because that's at the heart of diversification. This provision then says you are required to invest a certain way.
And I don't want to quibble with you, but isn't it fair to say that that paragraph E states these are the investments that the trustee shall invest in, correct?
Solely,
Yes, right.
yes.
And so the difference between this provision, and I'm going to ask you, submit to you that the difference between this provision that says you can solely invest in these assets and a diversification provision is a provision that would say the trustee may hold 100% of the assets in one stock, doesn't have to sell it. I'm going to ask, doesn't have to sell it, and is excused from having to diversify the portfolio.
Oh, that's a little more clarification. Yesterday in testimony, you referred to that as a retention provision, not a diversification provision, I believe.
Well, I referred to a retention provision and a
Oh,
diversification.
well, then my mistake. Then, as you just then clarified, a retention provision for assets provided, I believe that's at the tail end of paragraph E, as we talked about yesterday.
We talked about that yesterday, and I'm asking you about, there's a difference between a diversification provision and a retention provision, correct?
Okay, and perhaps this is where my confusion lies. Diversification has two meanings to me. Okay. Diversification has an investment meaning.
Okay.
Diversification, as I explained yesterday, along the capital asset pricing model line, the difference in asset classes, as we talked about, that's diversification of investments. Diversification. I believe the way you're talking about it, diversification means selling, means to take assets and to redeploy those in other assets. So maybe that's where the confusion was. It has two meanings. Is it the second that you're asking me about, sir?
Well, I'm asking about a diversification provision. You're characterizing diversification provisions as being two separate ones. That would be the first. I've never heard of that before. Is that something that I can find somewhere in the records, that there's two sorts of diversification provisions, something that you can cite me to that you relied upon?
Oh, excuse me, sorry.
That you relied upon? What did you rely upon to testify today that there's two sorts of diversification, one that talks about what you can invest in and one that talks about selling and redeploying the assets to have a more diversified portfolio?
Mr. Cook, I was really just trying to understand what you were asking me.
Okay.
I'm not sure from a linguist standpoint that I'm going to tell you where diversification means different things and how it's cited. I was trying to understand what you were asking me. Diversification.
Yes.
Diversification could mean selling, redeploying assets to diversify the assets of the trust. Diversification could also be the adjective describing how the trust assets are deployed. I was just trying to understand what you were asking me, sir.
Well, Master, I'm going to clarify this, move on. I'll submit to you when I speak of diversification, I'm talking about a specific provision that references the trustee shall have a duty to diversify or shall not have a duty to diversify, which means to sell out of concentrations. The other one we're talking about here, E, I'm referencing that as an investment provision that relates to what the trustee may invest in or shall invest in.
Okay, I'm not sure there was a question in there. Sorry.
I'm just asking, I'm submitting to, can we have an agreement that when I refer to it, so there won't be confusion today?
I'll do my best, but I have 35 years in fiduciary investing, and I'll listen to the question you ask me and I'll answer it as best I can, sir.
Okay. So if you look at paragraph E, and we'll talk about the investment provisions now, does E allow the trustee to invest in municipal bonds held by a state or a municipality?
It does not.
Okay. So if the trustee invested in municipal bonds that were held by a state or a municipality, is the trustee following the terms of the trust instrument?
No.
Okay. So, and I'll submit to you, and we can go back and look at, but you have a great memory. You've looked at the way that this trust is invested. Isn't it true that the trust heavily invested in tax-free municipal bonds, most of which are state municipal bonds or agencies of the state municipal bonds, correct?
No, that's not correct.
That's not correct. Well, let's go and look at, the accounting for the general partnership. That's going to be 10.
Tab 10?
Yes, it's 10 in mine. I'm not sure what it is.
I'm in your binder, sir.
Okay, look at 10, and that'll be easier to read. I think if you look at page 2 of 10.
10 is the Joseph Jamel 2012 trust?
No, Joseph Jamel 2012 Trust holds interest in the JDJ.
Wrong
for
binder.
Trust
Pardon
fund.
me. Mr. Cook, this is your binder.
That's it. Yes, yes, sir.
Go to 10.
Yeah. And you recall that,
Let me get there, please. Just one moment.
oh, sure.
Mr. Cook, you asked me about the trust and you're going to refer me to the partners.
Well, what does the 1989 trust hold?
Well, that's what you asked me, so I would have assumed just one moment later. Mr. Mr. Cook, I would have assumed based on your question, you were going to refer to me to tab 6, sir.
Well, we can look at tab 6 and then we'll go to tab 10. Tab 6, what is the 1989 trust? What's the asset in the 1989 trust?
And that's what you asked me, sir. It's a 14% interest in a limited partnership.
Yes, sir. The limited partnership, the accounting for that is on tab 10. I've asked you to turn to that.
And I'll be happy to. You asked me what the trust invested in. The trust invested in a partnership. The trust didn't invest in municipal bonds. The partnership invested in municipal bonds.
Okay, so what you're going to say is the trust only invested in a partnership. Is that correct?
I believe that's what the accounting shows here.
Okay,
That's what I've relied upon.
but again, and this is what we talked about all day yesterday, once you go to the accounting, it has the partnership interest. That's the sole thing that's in there. And then you go and look at the partnership interest, and within that partnership interest, is it fair to say it is almost 100% of the bonds are state or municipal bonds and not US or federal?
Yes, I believe that's on page 10.
Okay.
Yes, I believe that's fair to say.
Right. So if you're going to look at this as a trustee and parse through, because as a trustee, you have the duty of oversight, right? You have the duty to see what they're investing in. And if they're investing in assets that are not included in paragraph E, you're saying that's okay.
I'm saying the investment held by the trust is a limited partnership. Okay.
Okay.
And I believe that that investment in 2015 was retained based on testimony that I heard yesterday from Mr. Rob Jamel. So I believe that that asset, JDJ4 Trust Partners, was an asset that then when the qualified severance took place in 2015 was retained by the trustee, that partnership, if testimony provides.
Okay. So before I move on, I just want to make sure that what you're saying is your expert opinion that you are no longer going to go to look through the partnership and see how it's invested, which is what we did yesterday. You're no longer going to look through the partnership and see how it's invested because it's not invested properly in accordance with E. But now you are just going to look at the holding in the 1989 trust and say that all that it has is an interest in the partnership. Is that what you're saying today?
No, I don't believe so. I thought I just tried to answer it and I'll restate. I believe that JDJ4 Trust Partners was an asset of the 1989 trust. And when the 1989 trust qualified and severed in 2015, as you asked me at the beginning of my testimony where Mr. Dar Jamel became trustee, that was an asset that then was retained.
Okay. So, and now you're talking about retention. And I was not talking about retention. I was asking you a specific question about investments. Because yesterday you talked about the trusts are invested in 78% tax-free municipal bonds. And you did that across the board for all four trusts. But today, now what you're saying is this trust is invested 100% in a limited partnership. Isn't that a change from your testimony yesterday?
No, but I'd like to go backwards if I can to
Oh.
clarify something.
Sure.
Yesterday, after a long day, I was up here and I believe I misspoke. Now, Your Honor, I don't have the notes from testimony yesterday, but you just referenced 78%. I asked counsel if I had said that. The accurate figure is 68%. I apologize to the court. When you look through all of the trusts per the accountings, and I draw the distinction between accountings and investment values. Using the accounting values, it is 68% municipal bonds. It is 30% real estate and 2% miscellaneous stocks and others in cash.
Okay, so let's assume that was your testimony yesterday. If that's the case, yesterday you never said that these trusts held a certain percentage in a limited partnership. You parsed through it and went to the limited partnership yesterday, correct?
The questions that led me to that yesterday were about the assets and the holdings. So as I explained, and I believe you tried to draw a distinction between one trust and three trusts, which I had not done any analysis on, but I looked all the way through the partnerships investments and then as well the 2012 trust where there are other holdings. And I provided an answer, and I hope I've just clarified it. When looking at all of those four trusts and passing all the way through partnership or whether assets are held by the trust, in this case, the 2012 trust, the overall asset allocation from a diversification standpoint is 68% municipal bonds, 30% real estate, 2% miscellaneous stocks and others.
Okay. And today, what I'm just trying to clarify, because I asked you, is E satisfied because there are state and municipal bonds in the partnership, but you're saying the partnership isn't invested in bonds. Today, you're saying it's invested in this partnership. I'm just trying to clarify that today.
And I believe I answered yesterday in testimony. I went through each of the trusts and I said that the 1989 trust was 100% invested in JDJ4 Trust Partners. I believe I said that yesterday. I also said that the 1992-93 trust, as it's referred to here, is 100% invested in JDJ4 Trust Partners. I said that the 2012 Management Trust was 100% invested in JDJ4 Trust Partners. And then I drew the distinction with the 2012 trust being, I believe, 14% invested in JDJ4 Trust Partners, 83% invested or so in real estate, and then there were some miscellaneous guitars and amps and things like that.
Okay.
So I believe I did answer your question yesterday about what the trust owns, sir. Did I not? I'm sorry, I shouldn't ask you a question. Pardon me. I believe I answered.
All right. And I'm just trying to firm up your testimony today that you're saying that the trust is invested 100% in a general partnership. Correct?
I believe it's a limited partnership interest that the trust owns, sir.
Okay. If it's a general partnership, then we don't need to quibble, but we can look at it.
I'm just saying you asked about the trust, so that's what the trust owns, sir.
Okay. Where in E does it allow the trustee to invest in a general partnership?
In E, it doesn't allow solely in the first part of that. But as I said, I believe based on testimony that that is a retained asset.
Okay, so what your testimony is now is that, and I'm not trying to say now versus later, what your testimony is that it's invested in a limited partnership 100%, and it's not included in this list of items that could be invested in E, but that's okay because it was a retained asset, correct?
Isn't that the final sentence of E? May I go back?
But no, I'm just clarifying that.
No, I understand, but you've asked me, so let me make sure that I've referenced the trust agreement correctly. I thought I did, but it is the final sentence on 9, and I'll begin with after the semicolon. Provided, however, the trustee may retain in the form received any properties contributed to the trust other than cash or cash assets. And I
Okay,
believe based on testimony that when Dar became trustee in 2015, he retained JDJ for trust partners,
okay. And this trust was established in 1989, correct?
the original trust. Yes, sir.
Yes. And you're talking about the original, you're saying that JDJ4 was contributed to the trust in 1989, and therefore it's an original asset, and therefore it may be retained.
I did not say that, no.
Oh, okay. What did you say?
Um, I don't have anything to read back. I believe what I said was when Mr. Dar Jamail became trustee through the qualified severance agreement in 2015, that based on testimony yesterday, JDJ4 Trust Partners was an asset, and therefore he retained that asset under this trust agreement.
So if JDJ4 didn't exist until the severance,
Hmm.
that wouldn't be an asset that was contributed to the trust, would it? That was never contributed to the trust, so the retention language wouldn't apply to JDJ4, would it?
I'm not sure I can answer that question. What I read in the qualified severance agreement was the establishment of a successor trust. I believe it would have had a successor trust ID number.
Right.
It had a new trustee who came into those duties. They would rely on this trust agreement. They would look at the assets that came to them, and then this trust agreement would allow for retention. But I'm basing that on testimony yesterday, sir.
Well, I understand that, but I'm just trying to clarify what your understanding was, is that this references trusts that were originally contributed to the trust, but the trust was established in 1989. The JDJ4 Trust Partners wasn't created until 2015, 2016. But you're relying on the retention language.
Your Honor, I think at this point, this has been asked and answered. I
Give one
understand.
more shot.
And I might not be the person then to answer, but I will tell you that from a fiduciary investment standpoint, the qualified severance agreement to me created a new successor trust. It had a new trustee. I believe it had a new tax ID number. It is established off of this trust agreement. As the new trustee came in, they had to rely on the four corners of this trust agreement. So the 1989 trust then gave way to a successor 2015 trust.
And last question, isn't a qualified severance simply a severance of the trust, not a new trust? This isn't a decanting, this is a severance.
I'm not sure I can answer that question. I'm not sure I even understand it then.
All right, and I want to ask you the question, because I asked you yesterday, one trustee, Dar's the trustee of this trust, Robert's the trustee of the other trust. These rules are different compared to the other one. How are you able to kind of put all these numbers together and make a determination whether the trustee followed the trust investment provisions in the trust, have one global opinion that the trustees invested everything correctly?
Mr. Cook, you said the word rules. Could you clarify what you mean by rules? I'm not sure what that means.
Well, each of these trust instruments are different, correct?
Each of these trust agreements are unique trust agreements with their own provisions. Is that what you meant by rules?
Yes.
Oh, okay. I'm sorry. I wanted to make sure. Each of the trust agreements are unique. They have their own unique provisions within them.
Right.
They're the originating document from which a trustee then relies on, amongst other factors, in making fiduciary investment decisions. Yes.
All right. I want you to look at Exhibit 2 in my binder.
I'm there.
Okay. The investment provisions are on page 9, paragraph E. You see that?
I'm there, sir.
Okay. And then Robert's the trustee of this trust, correct?
Yes, sir.
Right now, paragraph E is very similar to the previous trust, paragraph E, but this one allows investments in state municipal bonds, correct?
Yes, with definitions related to that, yes.
Okay. So what is the holding in this trust? Trust number,
I believe I answered that several times. 100% JDJ4 Trust Partners.
okay. So where in E does it allow the trustee to invest in a partnership?
As I've said, the trust originating document begins it begins for the trustee where decisions are made, but it is not the sole authority in making decisions. And I believe just as we closed yesterday, there was a reference about the Texas Trust Code, section 117.
So does section E, show me in section E where it allows the trustee to invest. And this is what's limited for the trustee to invest, right? Because it says shall invest.
Mhm.
So show me where in E it allows the trustee, this trustee of this trust, Robert, to invest in a general partnership.
It doesn't.
Okay. If the trustee invested in a general partnership, in spite of the fact that E says you can only invest, shall invest in these items, but a general partnership isn't included, isn't it fair to say that Robert did not follow the terms of the investment provisions in the trust?
Did not follow the trust agreement, paragraph E's provisions. Yes.
Okay. I'm going to ask you again, and I'm asking you specifically now about diversification. And diversification is, as I'm referencing it, is a provision in the instrument that says that the trustee can hold an asset even though it's an overconcentration and is not required to sell out of it and fully diversify the portfolio. Do you see a provision in here that says that?
Beginning after the semicolon, provided however, the trust may retain in any form received any properties contributed to the trust.
That's a retention language. That's retention. I'm asking you about diversification.
Repeat your question then, sorry.
I'm asking you, and I'm asking the question, is there any provision in here that would excuse the trustee from having to diversify out of concentrations in a trust portfolio?
And I answered that question.
And you're saying that paragraph E is the
retention language specifically allows for the trustee to retain assets contributed to the trust.
okay, yesterday I thought I'd ask you about this. Well, let me ask this. Are there, what assets were originally contributed to this trust in 1993 that are still here?
I don't think the accountings went that far back. I can't answer that.
Well, it goes back to 2015. I mean,
We-
are any of those assets still here?
I'm sorry, repeat the question. I was.
It goes back to 2015. Are any of those assets still here?
May I refer to the accounting?
Sure.
The 2015 date sounds odd to me, but I'll take a look here. I'm going to move over to the larger accounting, if that's okay.
Oh, for sure. Yes, ours is tiny.
So I'm in, I believe, Ms. Pacheco's book, and we're on the 1992 trust.
Mhm.
Let me find the right tab to reference it. I believe that is tab 5 for the trust indenture in Ms. Pacheco's book, and tab 6 for the accounting. And I see assets, not as of 2015. That's where I was a little confused. See assets on the accounting as of 2009,
Okay.
sir, and then in 24. And what was your question? Sorry, I lost
My
that.
question is this, the trust goes back farther, but we only asked for an accounting back to that date,
Okay.
initially. But my question is do you see any assets that were present in 2009 that are still present now?
Not in this accounting, no.
Okay. So is it true to say that the retention language wouldn't apply? I mean, if they haven't retained any of the original assets, even assuming that 2009 were the original assets?
Yes.
Okay, so thank you. So the retention language doesn't apply. So I'm not asking about the retention. And do you understand the difference between a retention language and and an excuse of having to diversify the portfolio language. Do you understand the difference between those two?
I've been in court many times and I've been on trust committees and I've never heard the word excuse used. So that's what's
Okay,
perhaps confusing me.
and let me ask you
Excuse.
this. In Texas, the trustee has a duty to diversify the assets of the trust, correct?
Yes,
Okay. Is there any provision in here that you see excuses that requirement to diversify the assets of the trust?
there are provisions, but then as you outlined, the retention doesn't apply then.
Okay, so then, because the retention, you're saying the retention, I'm saying diversification. I would submit to you they're different, and I'm just trying to understand, they're, in your mind, they're not different.
One feeds to the other,
Well, they're different.
meaning retention could allow the trustee to maintain concentrated holdings and not diversify assets.
Very true. But here again, the retention language doesn't apply, so the trustee would have a duty to diversify the trust portfolio, correct?
Yes,
Okay. And again, you're saying that this trust 100% owns an interest in a general partnership.
yes.
Okay. And I want to, I do want to
With the staff.
ask you, yes, you said that. I do want to hand this to you. It's just demonstrative. I put this together. I want you to take a look at it. I'm going to hand it over to opposing counsel first. I want you to look at, again, JDJ Trust Partners.
Yes, you may.
Thank you, sir.
We're talking about this trust.
Judge needs.
Oh.
Thank you very much.
All right, so there would be a duty to diversify. I do want you to look at the accounting for JDJ Trust Partners.
May I use Ms. Pacheco's book again?
Yes,
Side?
please.
Yep. I'll find that tab then. for you.
Okay. We can't know where I put it. That's right.
I believe it is tab 12 in Ms. Pacheco's book. Yeah, that's the accounting, sir.
Yes, so I would ask you to look at page 2 of that accounting.
Okay, there.
And what I've done is I've put, and I'm asking you to look at it from the September 30th of 2024. I've put on the left side, here are all the assets, and then to the right, here are the bonds, this is the real estate, this is cash, these are securities. And can you look at that just to confirm that I put those numbers in correctly? You're going to have to assume that I've added them up correctly, unless you want to add them.
I don't believe I need to add them because I think in testimony yesterday, I said 93% was municipal bonds, 5% was real estate, and then there was remaining. So I believe your numbers are consistent with what I testified to.
Okay, thank you. And Your Honor, I'm going to ask that the demonstrative be admitted into evidence. He's had an opportunity to review it to confirm that those numbers are correct. He's used it based upon the accounting, and I think it would be helpful to aid his review, our review of everything, that these are the numbers for that trust.
I'm not opposed for that limited purpose of this hearing.
No objection from us.
Admitted for the purpose then.
All right, that would be exhibit, let's call it 33.
33.
I know it's a little out of order, and I apologize.
Okay.
Okay. So if Robert, as trustee, Robert Jamel, Mr. as trustee, has a duty to diversify, then he either holds an asset in this one trust, if we're just looking at this one trust, he has either 100% concentration in a general partnership, or if you parse through it, there is a 93% concentration in tax-free municipal bonds. Correct?
Almost.
Well, 92.7.
No, that's not what, he also has a duty to look across other trusts.
Well, no, before we get there, I'm asking you this question. I'm just asking you right now on with respect to this one trust. with respect to this one trustee, either owns a 100% interest in a general partner, or the trust holds a 92.7% interest in tax-free municipal bonds, correct?
Almost. Or this trust in concert with three other trusts, as is required
Right.
when looking at the common needs and circumstances of the beneficiary,
And I'm
have 60,
sorry, go ahead.
have 68% invested in municipal bonds, 30% invested in real estate, and 2% invested in miscellaneous stocks, cash, and other. I'm not familiar with how you're trying to parse it
Yes.
without looking at the totality, which a trustee is required to do.
And so what I'm doing is I'm asking you, this is a hypothetical. Let's assume that Robert has one trust, okay? He's the trustee of, and it's this trust. And the hypothetical is Robert has either a 100% concentration in a general partnership investment, which isn't allowed by the trust, or he has a investment in general partnership holding a 92.72% concentration in tax-free municipal bonds, okay? I want to ask you, under that scenario, does the trustee have a duty to diversify either the general partnership or the tax-free municipal bonds based on Texas law?
I'm going to object to the question, Your Honor. It's based on two hypothetical predicates that are not supported by the trust agreement. I think it's confusing, and I think it's inserting his statements and then conjoining it with a question at the end.
So I'm entitled to ask him a hypothetical. The hypothetical is pretty clear. It's this one trust with these investments. I'm not changing any of the facts other than that.
No, he is, because the trust agreements allow for trust investments to be held in a unified fund. He just stated two hypothetical things. Well, either you can't do this or you can't do this, and then he conjoined it with a question. So I'm happy to point out the provisions of the trust that talk about how they can hold it in a common fund, but he's suggesting that's not possible. It's two violative acts, and then he attaches a question at the end. He wants to ask this question, but that's otherwise not a hypothetical.
If this were a jury trial, I'd probably sustain it because of the potential for confusion, but
You understand what the trust says?
I'm a pretty good filter, I think.
I understand, but I think.
But you'll have time to come back and
Fair enough.
clarify that for sure. So I'll allow the question. It's
Thank you.
overruled.
Yes. So I'm just trying to base this on what you testified to earlier, that the trust either holds a 100% interest in a general partnership, or the trust holds a 92.72% interest in municipal bonds. Okay. Do you understand that hypothetical? And this is the only trust he holds. That's the only fact that I've changed, is that it's this exact same trust, but it's the sole trust that he's the manager of. He's the trustee of. Okay. Are you with me?
Yes.
All right. Under that scenario, if this was the only trust he had with these assets, under Texas law, would he have a duty to diversify the holdings of the portfolio?
I don't believe so.
You don't believe that in that instance, Texas law would require him to diversify?
Well, as I said yesterday, there are many factors that go into the decision to diversify, using the word you just used.
Mhm.
And I spoke about the needs and circumstances of the beneficiary. I spoke about the grantor's wishes. I spoke about the trust agreement. I talked about the special skills of the trustee. So I'm not sure in your hypothetical, it would automatically draw me to the conclusion that we should diversify. Yesterday in testimony, you asked me about would 78% lead me to some conclusion that the trust was not diversified. So I'm trying to answer the question consistently with what I did yesterday for you, sir.
Okay. Would you consider 92% of the trust in one sector, tax-free municipal bonds, to be a concentration of the trust?
Yes.
Okay. And so what I asked you was, in Texas, there's a duty to diversify unless there's an excuse, right? Correct?
Yeah, in
Some
excuse,
special
unless there's a
circumstances.
reason, yes.
Right. So my question was, would he have a duty to diversify these assets? And you went straight to the excuse, correct?
Well, sir, as somebody who's been a professional fiduciary, I look at the totality, and I believe a trustee has to do that in making investment decisions. it isn't just one thing.
Mhm.
So as you asked me yesterday about the 78% question, I would look at the reasons for holding investment assets
Okay.
and the needs and circumstances for the beneficiary for income, for the accumulation of income, the timing on these trusts and where termination could be.
Uh.
It could be very appropriate. I can't jump right to the conclusion that they should be diversified. No.
No, I didn't ask you that. I asked you if he had a duty to diversify. I didn't ask you if he should. I asked you if he had as a duty to diversify in that instance.
Then we're back to the hypothetical. A trustee has a duty to diversify. Yes, sir.
Yes. So under the circumstances, you're saying there's special circumstances that would have allowed him to not diversify, correct?
Yes, and
That's what I'm asking you. Under the circumstances, what do you believe are the special circumstances that exist that would allow him to hold a 92.7% concentration in tax-free municipal bonds? What are the special circumstances that would permit him to do that?
I believe I answered some of this yesterday, so I'll try and go back over it. There are conditions by which under the Uniform Prudent Investor Act that you look at market conditions. I believe you asked me, or someone asked me, pardon me, about what was going on in the bond market. You look at inflation, you look at tax consequences, you look at the needs and circumstances of the beneficiary, as I've said repeatedly here. In this case, you also look at the timing of trust, the potential termination, the need for distributions, for cash flow. I relied on testimony yesterday about the lack of productive income. So the total of all of those, along with the special skills of the trustees, would be reasons for retention.
Would you agree with me that market conditions, timing, the need for distributions, cash flow, those things would change over a period of 30 years?
Oh, certainly.
Okay, but the investments never changed. So that's what I'm trying to understand. If you said special circumstances exist to allow this, and these things that you said, market, timing, need for distributions, cash flow, those would be the special circumstances of the factors, but you also agreed with me that those factors changed all the time. If those factors that you said allow special exceptions change all the time, how come the investments never changed?
So I only agreed with the ones that you listed.
Okay,
Let me cite ones that maybe have not changed.
all right.
I heard in testimony yesterday from the age of majority to present about the circumstances and needs for the beneficiary, that there has been no productive income, that whether through family gifting and or trust distributions, that's the means by which lifestyle has been provided. The beneficiary's needs and circumstances are one of the key components in making investment decisions for a fiduciary. That's one. I also explained, because we're sitting here today talking, believe an emergency hearing, I also explained the present circumstances, not just the timely circumstances over time, about diversification and their implications for municipal bonds and the like.
Okay, so you said that circumstances associated with the beneficiary, correct?
Correct?
The beneficiary was an infant in 1993. The beneficiary is now 32 years old. The facts and circumstances changed on that factor have changed significantly between 1993 and now. Why has the portfolio not changed?
Well, sir, as we did with the accounting, I'm going to go back to 2009, which is close to the age of majority for the beneficiary. Because I don't have data further back than that. And I specifically referenced from age 18 through, I believe it was age 32 presently for the beneficiary.
Okay. Let's talk about the management trust now. You're familiar with
The
management trust?
2012 management trust, yes, sir.
Yes. And if you'll look at, I believe it's exhibit,
Put that aside.
I believe it's exhibit 3.
In your binder, sir?
Yes, sir. That's the Joseph Dar Jamel 4 Management Trust.
Yes, I'm there.
You're familiar with, I guess this is self-settled irrevocable trust?
Yes,
Okay. So Joe's the beneficiary. Joe the fourth is the beneficiary, but he's also the grantor.
yes,
Okay. Earlier you were talking about other trusts and you were taking the grantor's intent into effect when making investments in the trust. The grantor at this point was Big Joe or Joe the Third. Here, the grantor is the beneficiary, correct?
Yes,
So if the beneficiary, who's also the grantor, says, you know what, I would like my trust assets diversified. Isn't that the grantor's intent? Isn't that a clear expression of what the grantor's intent is?
it could be, yes,
Okay, so should the trustee have taken that in consideration? If the-
yes.
Okay, and if the grantor doesn't take that in consideration, I'm sorry, if the trustee doesn't take the grantor's intent into consideration, then how do you think that would affect whether or not the trustee properly invested the trust assets?
You used the word consideration. I heard nothing in testimony that said that it wasn't taken into consideration. In fact, I believe I heard from both trustees that they listened and talked with the beneficiary about his wishes. So consideration is different than direction, is different than action.
That's true.
So I'm not sure that I follow your question, sir.
I'm just asking you if the beneficiary, so also the grantor here, expressed a desire that the assets should be fully diversified, that would be the grantor's intent that should have been taken into consideration by the trustee.
And I heard that it was. Yes, I agree, if that's what you're asking me.
Okay. All right, so now I want you to we're going to look at the investment provisions. And that is on page 15.
I'm sorry, which exhibit are you looking at so I can?
It's exhibit 3. I'm sorry. And that's in our book.
Pardon me, yes.
It's on page 14. I'm sorry, it's on page. Actually looking at a different provision now. Apologize. I'm looking for that. I'm sorry, I did not mark that well. Oh, look at page 9. Page 9 of exhibit 3, section 7.4.
I'm there.
Okay. Section 7.4 talks about trustees' powers and the powers to invest in A. And is it fair to say that the investment powers of the trustee are definitely broader in this trust instrument than they were in the other two?
Yes,
Okay. And so the next thing I want to point you to is paragraph 7.6 on page 14.
okay, sorry.
Okay.
Yes,
Paragraph 7.6, page 14, collection and retention of assets. Investments need not be diversified, may be of a wasting asset, and may be made or retained with a view to possible increase in value without requirement that the investment produce current income. Do you see that?
yes,
It has a reference to retention, but it also has a reference to diversification, correct?
in the negative may not be.
Yes.
Yes,
Because it says here specifically, the investments may not need to be diversified, correct?
yes,
Okay. So would you agree with me that that is a provision related to diversification?
yes,
Okay. And would you also agree with me that that provision potentially will take it out of the duty of in Texas law for a trustee to diversify, correct?
with the understanding the word is may.
That's my next point. Diversification provisions can be mandatory, shall, and they can also be discretionary, may, correct?
Yes,
Would you agree with me that those are different?
yes,
Okay. Would you agree with me that if the trustee has the authority to shall not diversify, why would somebody say something like that? The trustee shall not diversify the assets.
I Why would, hypothetically, why would somebody, I'm not sure I understand.
Yes, well, let me ask you this. I mean, typically isn't the way that that goes is somebody puts in the ranch, the family ranch, and they say, you shall not diversify the assets of the family ranch. Don't sell those because I want everybody to use them. Correct?
Yeah, that could be an example, yes.
Okay. Another one in Texas especially, shall not sell the Exxon file. Correct?
Sure.
Okay. But if it says may, it's different, correct? How is it different? Why is it different from shall? Why is it different from a mandatory provision?
Because it provides the trustee more discretion.
You think it provides the trustee more discretion? Oh, that the trustee may diversify or may not diversify, correct?
Could you rephrase the question? I thought I
Well-
said it first when I answered, but now I'm not sure.
Well, that's why I asked you the difference. What's the difference between, we talked about what a shall is, but what is a may? May diversify the assets.
I think I did answer it correctly.
Yes.
A may provision allows the trustee more discretion in making the decision.
Right. The trustee may or may diversify or may not diversify, correct?
Yes,
But the trustee still has to use and rely upon sound investment policy to make that decision. Isn't that correct?
yes, fiduciarily prudent investment.
Correct. So if it's a may, discretionary, and therefore the trustee has to use his, I think, what did you call it? His fiduciary
Fiduciarily investment, a prudent investment.
prudent investment.
I'm
There you
trying to
go.
reference specifically the Texas Trust Code.
Yes, sir.
There's a sentence in there.
Okay, thank you. That's what I was looking for. So let me ask you this now, and I don't want to belabor that anymore, but let me ask you this. If Robert's the trustee of this trust and he has the discretionary ability to diversify away, but he's also managing another trust that he does not have any discretionary authority to diversify, how do you square that in your opinion? How do you divide that in your mind? Do you just throw them all together and say, well, he's got discretion to diversify everything because he has it under one instrument? How do you divide that?
I didn't catch the final. He has, what would, one instrument? I didn't,
So Robert's the trustee of three trusts.
yes.
All right. The one trust we talked about really didn't have a diversification provision in there. There was nothing related to diversification and the retention language didn't apply. So if you have a trustee here where he has one trust that he has a duty to diversify under Texas law, and he has another trust that he has a discretionary ability to diversify or not, how do you lump those together when you're doing your opinion?
And by lumping them together, I think I've answered several times. As trustee, you look across the trusts. Yes, you're guided by the original instruments in each agreement.
Right.
But you have a duty because the beneficiary here, their needs and circumstances, you look across those. And as you do that, you look at diversification in total. And I've provided those percentages in my view. I believe I've answered your question several times.
Well, this was a more specific question. The question was, if you have one trust instrument that doesn't allow, that requires you to go back Texas law and diversify unless there's a special exception, and then you have this trust instrument that allows mandatory discretion. When you do your analysis and your opinion, my question was, are you taking the assets of that trust that requires diversification and the assets of this trust that don't require diversification, and you're coming up with one opinion?
And you're asking me from an investment standpoint, right?
Well, from a trustee, fiduciary duty, investment standard, based upon two different instruments that have two different standards.
I heard you ask me before somehow to square trust agreements, and I'm not a lawyer, so I couldn't answer that question. But I think I've answered now for a fourth time. From a fiduciary investment standpoint, the needs and the circumstances of the beneficiary are taken into account. You look across four trusts. You look at the diversification for the holdings across four trusts. I'm not sure what more to add to answer your question.
Well, it's important.
Your Honor, I think at this point it's been asked and answered. The other thing is maybe we could take a quick break. I don't want to interrupt Mr. Cook's flow, but in an hour in.
Well, the only reason why I don't believe it's been asked and answered is because he says he doesn't understand the question. And so I may or may not explore that. Let's take a break and then figure out where we go next. Or if the judge wants to. I mean, I'm sorry. I'm like, shots. Hey.
I'm a go along to get along kind of guy. If you all want to take a break, I'm fine with that.
I just need 5 minutes to run to the restroom.
I
It's a morning
understand.
break.
We'll take a break, but we have a very short time today. Are we going to be able to get through? Because
Yes.
But I'm hoping.
I don't think so. All right, let's take a
5 minute break.
Let's take a 5-minute break, but I know you'll be back in 10, but we'll see.
I'll be back in 5 if that's what it takes.
Cook, are we ready to pick up where we left off? Okay, thank you. Oh, very good. So Mr. McIntyre, I think, is next here. Do you have any questions of the witness?
Your Honor,
Mr.
Mr.
Saddle?
Saddle is going to interrogate this witness with your permission.
Of course.
I take offense to interrogation.
Yeah,
Your
me
Honor.
too. Can I say that?
And my apologies, Your Honor, we're having a vibrant discussion and good morning, Mr. Dahl.
Mr. Seidel?
I'll be briefly examining you. Anything that I am inquiring about is limited to the 1989 trust. Can we agree to that?
Yes, sir.
Let's see that in the binders in front of you. I believe that trust agreement is exhibit number 1.
That would be Ms. Pacheco's?
Ms. Pacheco's exhibits.
Yep, I can do that.
And can you turn to page 9 of that trust?
Yeah, I think we've been there, sir. I'm there.
And you and Mr. Cook had a lengthy exchange about paragraph 9, which is Article 4, Section E, correct?
Yes,
Or a better way to ask that question, Article 4, Section E is contained on page 9 of that trust, correct?
yes.
And have you reviewed any modifications or additions, deletions to Section E of Article 4 of this trust agreement?
No, sir. Page 16 has signatures. I don't, other than perhaps the qualified severance.
May I approach, Your Honor?
You may.
And just for identification purposes, a certified copy of a judgment rendered in cause number 255110, probate court number 3 here in Harris County, Texas. That's on the first page of that document. Mr. Dahl, that looked like what I handed you. Is that what I handed you?
Sorry, I'm looking at it, sir. Just give me a second. Yes, it does.
And have you ever seen this document?
No, sir.
Your Honor, given that it's a certified copy of the judgment entered by probate court 3, I would go ahead and offer it.
I haven't seen it. But are there any objections?
I did not.
Oh,
Your Honor,
yes, sir.
I don't have a good way to do this because I don't have another certified copy.
That's okay. Just so that I can,
That one, Mr.
no, it's just so I can follow along. That's all I want to do. All right, thank you. Is there any objection?
This is a certified file document. We've never.
Have you requested it in discovery?
Yeah, I request all documents related to investment. All those things. They did not respond timely. They did respond today. They did not produce.
Your Honor, this is a public record.
Right, but it was requested in discovery. Have you responded in a timely fashion?
Your Honor, I will fall on the sword. There was a miscalculation of deadlines, but we have since.
Well, I think Mr. Cook is invoking the exclusionary rule here. All right. It's not admitted.
Mr. Dahl, in that case, we won't talk about that, but let's just focus on the accounting of the 1989. You've reviewed the accounting for the 1989, correct?
Yes, sir. I believe that's tab 2.
And you have reviewed the accounting for the 1989 trust that was severed for the benefit of Joe, correct?
Yes, sir.
And in your review of those accountings, you discover any indication of any missing funds?
Very quick on the call.
But did the expert witness review the accountings in preparation for his testimony?
Yes, Your Honor.
I think the question is were there any, did you see any or discover any missing funds? That's not an expert opinion. It's just simply what have you reviewed and what have you seen? But based on that, objection's overruled.
So I can answer the question. I'm
You
sorry.
may answer the question. Yes, sir.
I did not see any missing funds, and I reviewed it from an investment standpoint to move from beginning to end. So
And in your review of those accountings, did you identify any assets that?
no,
And in your review of those accountings, did you identify any losses?
I can't answer that because the book value transactions, there weren't enough details on how some of the assets changed. They may or may not have been losses in the accountings.
Your Honor, with that being said, I'll pass it.
Thank you. Ms. Pacheco.
Yes, Mass, just a few follow-up questions.
Yes, ma'am.
Mr. Dahl, you were asked a lot of questions about these trusts of whether a specific provision allowed for investments or diversification or non-diversification. Do you recall that?
I do.
Do you look at one provision in a trust when you render your opinions, or do you look at all the provisions in the trust?
All.
And in this case, did you look at all the provisions in the applicable trusts?
In each of the 4, yes.
Now, I want to start with the 1989 briefly. Let me ask you, if a judgment existed that authorized the trustee of that trust to invest in state and local bonds, would you have an opinion whether the investments were authorized under the trust agreement?
She's
You're-
asking hypothetical.
I'm asking a hypothetical, Your Honor.
Could you repeat the question? I got.
Yes, Mr. Dahl. My hypothetical was if a judgment existed that authorized the trustee to invest in state and local government bonds, would the investments of the 1989 trust as severed, would that fall within that authorization?
Yes, it would.
Now, with regard to the 1993 trust, which is the first of the 3 trusts I'm going to discuss with you that my client Rob Jamel is trustee of, that's Exhibit 5 in your binder.
There.
And I apologize, I may move a little quickly because I do want to keep this going. Mr. Cook asked you a lot of questions about paragraph E on page 9. Do you recall that?
I do.
And I believe under that limited paragraph, you gave certain opinions about whether it could be inside a partnership or outside a partnership based on that particular paragraph, correct?
That's correct. He asked me specifically about this paragraph and this paragraph alone.
Okay. Is there other paragraphs of this trust agreement you considered or authorization under this trust agreement you noticed that would give broader authority for retaining or investing through a general partnership?
Yes, absolutely. The ability to invest in joint-based investments. I'm going to have to read through the trust agreement to find it specifically.
Okay, if I turn you to page 12,
Thank you.
paragraph G,
It's always- Yes, that's it.
is that the provision you're referring to?
Yes, it is.
And there's also page 10, paragraph 2A. Did you review that paragraph before?
Let me come backwards, please. Oh, of course, yes.
And are these paragraphs, how do these paragraphs weigh into the opinion you previously rendered in this case?
Well, as I tried to continue to broaden it out, it's not just one provision, one paragraph, it's the totality of the trust agreement and then the trust code, the Uniform Prudent Investor Act. These are specifically what allow for an investment in JDJ for trust partners.
And is that because, again, JDJ Trust Partners invests in the authorized investments, bonds and things of that nature?
Yes, in the case of this trust that we're talking about, pardon me.
And then the next trust I'm going to ask you about is the management trust, correct? It is Exhibit 7.
I'm there.
And Mr. Mr. Cook asked you about diversification or lack of diversification in this trust. Do you recall that?
Yes,
And he limited his questions to certain provisions. Was there other provisions that in your mind authorized the investments in this particular partnership?
yes. In fact, Mr. Cook originally referenced me to page 14. I anticipated that that's the question he was going to ask me about paragraph R on page 14, but then we went backwards.
Paragraph R, let me get there, okay? Let's look at paragraph R. It says joint interest and commingling.
Yes,
Okay. And what of note did you relate to as it relates to your opinions of paragraph R, and how do those tie into your opinions?
similar to the question you asked me before, this is what authorizes JDJ for trust partners to be an appropriate investment.
And did Mr. Cook ever ask you on page 10? It's under paragraph 7A7. You see that up there?
I'm going, sorry.
Did Mr. Cook ever ask you about that paragraph 7, the last of the investment
No, he didn't.
authorizations? And what does paragraph 7 provide?
The ability to invest in and hold limited partnership interests.
And then finally, we have the other 2012 trust, which is Exhibit 9 in the exhibit binder. Mr. Cook asked you about specific paragraphs of that instrument. Do you recall that?
Yes,
Beyond the specific, again, is it one paragraph or the agreement that you have looked at in order to render your opinions?
the entirety of the agreement and agreements.
And again, your opinion was that the trustee invested appropriately under the terms of the agreement as to the other 2012 trust, correct?
The one we're on right now?
Yes, sir.
That's what you meant by other?
Yes. Okay. And again, was there a particular provision in this trust that you noted or considered beyond the specific limited ones that Mr. Cook talked about with you?
I'll have to find it because Mr. Cook didn't lead me into this trust agreement. He led me into the other one. So absent reading quickly here. The trusts were similar. So page 15, paragraph 7(1)(a)(7).
7(1). I'm sorry, what page?
I believe it's page 15.
Okay,
Article 7(7)(1)(a)(7).
okay.
And that's similar, consistent with the 2012 management trust.
Okay.
My answer is the same.
Okay.
And then page 19, paragraph R. Again, similar to the 2012 management trust.
Okay. And so again, did you consider those paragraphs along with the totality of this trust in rendering your opinions in this case?
Yes,
And Mr. Cook asked you a lot of questions, pointed out some provisions of the trust. Have you changed your opinions as to whether the trustee appropriately invested the assets of these trusts? Particularly, I'm going to limit my first questions to Rob Jamail, as it relates to the 1993 trust, the management trust, and the 2012 trust.
no, I have not.
I pass the witness, Your Honor.
Yes, sir.
Mr. Checker was asking questions and you did very agreeable on the example. He said,
Your Honor, I'm going to object to the sidebar.
Let's continue.
that Mr. Quick asked you questions about the default trust, and you said, "Didn't ask me questions."
Your Honor, he asked you questions about all four trusts in multiple times.
Did I ask you?
I believe you asked me questions about the 2012 management trust.
The 2012, okay, it's your testimony that I asked you. Mark and mail. Real estate interest.
You asked me questions that I answered about the totality across four trusts. You asked me questions specifically about provisions, and I believe I've just testified. You referred me to page 14, but then back to page 10, and that was the 2012 management trust.
Nothing further from us, Your Honor.
I have nothing further, Your Honor.
Thank you, Mr. Dahl. You may step down.
Thank you, Your Honor.
Can we excuse Mr. Dahl from the proceedings?
Yes, Your Honor.
Mr. Dahl, you're free to go. Thank you, sir.
Your Honor, at this time, we call Lily Jamail.
I'll bring her in. Hello, Ms. Jamail. How are you? Ms. Jamail, Lily Jamail, we're ready to have you testify now.
Hi.
You are. Okay. All right. So you've been called to testify. I'm going to swear you in, and then three attorneys will take turns asking questions. Okay?
Okay.
Would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Thank you.
Your Honor, may I proceed?
You may.
Ms. Jamail, my name is Sarah Pacheco. I represent your uncle, Rob Jamail. We've met briefly, I think yesterday. Is that correct?
Yes.
You understand you've been asked to testify today about some facts that we believe are relevant to this proceeding. Is that a fair
Yes,
statement?
ma'am.
And you have not been told what's been going on in this courtroom, have you?
No.
I want to start out by just having you state your legal name and so you can introduce yourself to Judge Semino.
Lily Marie Jamail. I'm Joe's older sister.
And don't take this badly, but we got a lot of Jamails. So when you say Joe, which Joe are you referring to?
Joe Jamail the fourth.
Okay. And who is your dad?
Dar Jamail.
And who is your uncle?
Robert Jamail.
And do you understand what this proceeding is currently involving?
Yes, ma'am.
With regard, I want to start with first the trusts. You yourself have been beneficiaries of various trusts along with your brother. Is that correct?
Yes, ma'am.
Have you ever met with either your father, Dar Jamail, or Robert Jamail regarding the trusts that you were a beneficiary or are a beneficiary of?
Many times.
Was your brother ever present?
Many times.
There's been a suggestion in this case that your brother has not been receiving information regarding the trust. And when I talk about the trust, I want to clarify, there's something called a 1989 trust, a 93 trust. I think yours was a 92 trust, and two 2012 trusts. Are you familiar with those trusts?
Yes, ma'am.
Did you ever meet with your brother with either Dar or Rob Jamail to discuss those trusts?
Many times. In person, over the phone a lot of times. We would talk about it at dinner probably 4 to 5 months with the papers in front of us. Sometimes during the day.
Describe to the judge who was typically at these dinners or these meetings.
It would always only be my brother and my dad and I. And with Rob, a lot of times it was over the phone. Or if we had questions, we would call him, you know, after the fact, but I know that we would have many conversations with them all present too.
Did you ever hear your brother ever express that he hadn't been provided a copy of the trust agreement?
Not until all of this arised in like about a year ago, because it was just not true, like he was there.
Um, Did you ever hear your brother express that he wasn't being given information about the trust?
He told me about a year ago, the last time I saw him in person, he came over and said that we have been being lied to, but it wasn't being lied. I mean, he wasn't able to like have a conversation with me because he was so just angry. And when I would ask him like why he thinks that we're being lied to, like it's all in the paperwork, he would just say that we're just supposed to have our money. But we've always discussed that we were and we wanted this, you know, like I was there when he said that he wanted this too, to keep investing our money how we've been investing, and uh to use a portion of it as a sort of like allowance for us to live off of each month.
So that you're leading me to my next question, which is the investments of the trust. Are you familiar with discussions that Joe was present, where the investments of these four trusts were discussed?
Yes,
Was that just on one occasion or how?
multiple occasions. Every time we would talk about it.
You said you were at many dinners with your father and Joe, your brother, correct?
Yes.
During those dinners, did you hear, or did you become familiar with the general investments of these trusts?
Yes, and I think I even have pictures that I took on my phone of, I mean, honestly, of just so that I would have the papers and know what we're talking about when my dad's talking to me about it over the phone. But yes, I know for a fact that that is true.
Do you have any concerns that your father or Rob has ever mishandled any of these trust assets?
No, and whenever I would ask to do something differently, we would do it.
I want to talk about Joe for just a minute. That's your brother, correct?
Yes.
Do you have any other siblings?
Mm. I have step siblings. My stepfather was in the courtroom yesterday and for our first day in trial.
Joe is your only sibling.
Yes, my only Jamel sibling.
And historically, how would you describe your and Joe's relationship?
Well, we've been close, you know, up until I would say about a year and a half ago. This has been the longest I've gone without talking to him, and it's been hard for both of, I mean, I don't know about him, but you know, I would try to reach out, just try to like fix it because we would get in fights sometimes, but like pretty normal fights. But then the fights started like escalating like 2 years ago to where we just couldn't really talk without getting in a fight. But about a year, he would come over and spend, you know, like the weekends with me at my house and like Thanksgiving with me and stuff. And we had like a good relationship up until um I would say about a year and a half ago, where like the last time he came to my house, it was just during the day and I was swimming. And I remember like very vividly, I asked him within the first 5 minutes, I had a friend over too, like how he was doing. And I was like happy tone. I was just trying to keep it like light because I could tell he was like not doing well. And he got really upset that I asked him how he was doing. And then I think because he told me it's because he thinks I'm insinuating that he's not doing well. And
Well, let me pause you there because I have to keep it question and answer.
Mhm.
Do you have concerns about your brother's health?
Yes. And I was going to say in this one this is just one of the moments uh, he he yelled at me and just told me to shut the fuck up. And I don't know what I'm talking about when I'm asking him these things, and then slammed the door, and then I had to lock him out. And then he begged, and he said, he came back and he said he was sorry. And he would just want to talk to me if I would let him back in, and I debated it, but I let him back in and I said, it's okay. I didn't want that in my house.
Do you have any concerns about his mental health?
Yes.
What are those concerns?
Well, they used to be, uh, that he was just depressed and kind of off, didn't know how to like handle his emotions. But now it's much more than that. He has disowned, he told verbally to my grandmother and my aunt that he's disowned them. He yelled at them in their yard because they wouldn't help him. Um, but yeah, like after he yelled at my
I'm
grandmother,
sorry.
Hold on,
Ms.
Mr. Mail.
Jamel?
There's
Mr.
an
Mail?
objection in the courtroom,
Sorry.
so I need to ask you to pause.
I can't hear. I can't hear what he's saying.
It's okay. He's addressing the judge, and I have to
Oh,
answer
okay.
the question for him, and then I'll instruct you. As to hearsay, objection is sustained. So, Mr. Mail, in court, we're not allowed to say what other people told us unless they're a party.
Okay.
Okay.
I just want to limit it to your observations.
Yes,
Are you-
there was one incident that happened that made me think that I wasn't just the only one. I thought he was just maybe angry at me, but then with multiple people, it made me realize that like it's much deeper than like an anger towards me, and the anger and his like mood swings have increased like in double the amount that they used to be, I would say, in my opinion, over the last year and a half than they have in the past. Like I would say he hasn't been doing well, in my opinion, from when I've seen him in the past 5 years. But in the last year and a half, it's like doubled.
Thank you, Mr. Mail. That's all I have. I appreciate your time today. I have to pass you as a witness, and I'm just saying that because you're on Zoom. There may be other lawyers that ask you questions, so don't hang up.
Okay.
All right. Mr. Cook. Is your microphone on? There we go.
Mr. Jamel, can you hear me?
There we go.
Yes.
I'm sorry. My name is David Cook. I represent Joe Jamel, your brother. I thought that you had testified that you hadn't seen your brother in the last year. Do you recall?
I don't remember when it was specifically, but maybe was a year and a half ago.
Okay. But then you testified that he's gotten worse over the past year and a half. So I'm just trying to square that with,
I mean, I've talked to him. I haven't seen him, but we've exchanged texts.
okay. So over the past year and a half, you've exchanged texts with him and you based your opinion that Joe is getting worse on those texts.
Yeah, and like I mean, doing all of this is,
Okay.
I would say,
So the other question I
and
have,
also like
objection
usually.
unresponsive.
All right. I'm sorry, Mr.
Wait,
Mayor.
can I finish, please?
Actually, no. He's made an objection and I've
Okay,
suspended it. So,
okay.
but he'll come back and ask another question, Mr. Mail.
I think she was just trying to answer the question that he got
I was
off.
trying to answer, yeah, the
Okay.
previous.
I'm sorry, I'm ready to move on to the next
We
question.
can come back if you want to follow up on that.
And I appreciate it. I just think it's one thing if it's not responsive, but what she was saying was responsive and he cut her off because he didn't like the answer.
Move on.
Yep.
Yeah, fair enough.
Thank you.
Okay. And so,
Right or wrong?
you've testified that you were in meetings with your brother along with Robert and Dar. Is that correct? Or just Dar?
I mean, some were with Rob, but mostly, I mean, I have so many vivid memories that Joe and my dad and I would sit at the table and look over.
Objection non-responsive. I'm just trying to get a sense of, and we don't have a lot of time.
Okay.
The question I ask is, in these meetings, did you meet with you and Joe and Rob, you and Joe and Rob and Dar, or were you
I'm
and Joe?
saying some of them Rob was there,
Okay.
some of them he was not.
All right. And you guys met regarding your trust and Joe's trust, I guess, at the same time?
Yes.
Okay. And Do you know, is your trust invested the exact same way as Joe's trust?
No,
Okay,
I mean, there's some differences. Joe has a little bit more stock because he wanted it.
okay. And that's the only difference?
Um, I, I don't know if that's the only difference.
Okay. I'm just trying to get an understanding of your specific knowledge about what's in Joe's trust and how your trusts are different. Do you have any specific knowledge about that?
Um, I mean, I know they're a little different. I don't know the specifics of it, but I know that he has a little bit more in stock
Hmm.
than I do. But mostly, I mean, we both wanted, to have this tax-free income that we were getting off of the bonds that most of our money is in.
Okay, did you receive tax-free income from the bonds?
Yes.
Okay. How'd you receive your tax-free income?
Um, what do you, I don't know how to answer that question. I'm sorry.
Was that distributed from your trust? Was it retained in the trust?
Oh, well, as of recently, I took some of it to use and then I reinvest it.
Okay, and I guess in these investment discussions that you had with Dar and Robert, I guess they also said whether or not they distributed income to Joe.
Yeah.
Did they distribute income to Joe?
I mean, for in the past 6 months, I know he's been using a little bit of it for his like allowance,
Hmm. Okay, what about before the last 6 months?
but I wasn't using any of that either. So yeah, we were agreeing that it wasn't distributed to us. It was being reinvested.
So if you haven't met with Joe in the past year, and you said in the past 6 months, you know that distributions have been made to Joe, how did you know that?
Because my dad showed me the paperwork and
So your father showed you the paperwork of Joe's trust.
yeah,
You're not a beneficiary of Joe's trust,
well,
correct?
it was okay.
Right?
Um, no,
Why would your father show you, or why did he indicate to you that he was showing you confidential trust information of Joe's trust?
because I'm his sister.
Okay.
So it's just so we know what's going on with both of our, it was kind of just like, this is what's going on with Joe's and this is what's going on with mine.
Did your father ever give you a copy of the trust documents?
I didn't ask for a copy.
Okay. Did you ever see your father giving, because during these meetings, did you ever see your father giving Joe a copy of the
Yeah,
trust?
and actually, we have texts with the pictures of, the papers that we would look at. I know if I could go back in my text messages and see
Okay,
that my dad would share that with us.
okay, so you're saying that your dad shared copies of your trust instruments with you on text. Is that correct?
Or, I mean, yeah, but it was kind of just like notes.
I'm asking a question. Did your father ever share with you a copy of the actual trust instrument?
I don't know if it was the actual copy.
Okay. Did you ever see during these trust investments where your father Dar provided Joe with copies of the trust instruments governing the trust for Joe?
I'm not sure.
In the meetings that you had with, including Robert, did you ever see Robert share a copy of the trust instrument with?
I don't remember, but if the question is if Joe had access to the information, he did.
No, that's not my question. My question
Okay,
was, did you ever see your dad or Robert provide a copy of the trust instrument during these meetings to Joe?
I don't remember.
Okay. Did your father ever tell you about a concentration of assets in the stock, in the trust?
I don't know what that means.
Okay. Did you ever see your father, let's see, did you ever receive income tax statements from the trust? Oh, let me just ask specifically with Joe. Did you ever see Robert Ardar during these meetings share trust tax information with Joe?
Yes,
You did. trust income tax returns?
I mean, I don't, I think so.
Okay.
Yeah, I mean, I think that was part of all the papers that we would go over.
Okay. And what about trust investments? What about statements related to trust investments? Did you guys go
Yeah,
related to trust investments? Did
yes.
Dar and Robert give you guys copies of the trust statements showing what was in the
I'm
trust?
sure they did.
Okay. What about if Dar and Robert both said they did not give statements to Joe? How would that affect your testimony?
I don't know because this is mine. I don't know if, I don't know if we're actually talking about the paperwork being handed to Joe or just going over it. Because I don't know if they handed him like a physical copy, but I know that we would discuss it and look at it together.
Last witness.
Final?
Just a few questions, Your Honor. Ms. Jamel, did your father ever refuse to give you any information about your trust?
Never.
So you have never asked your father, hey, how am I
No,
doing? And he refused to answer?
absolutely not. He wanted to talk about it with me way more than I wanted to talk about it with him.
And
And whenever I showed interest in it, he'd be like, he would jump to the occasion to talk to me about it. And same with Joe.
and if I ask the same questions about your Uncle Robert, did your Uncle Robert ever refuse you to give you any information about the trust?
No.
Ask the witness, Your Honor.
Ms. Pacheco?
I have no further questions. Ms. Jamel, thank you so much for making time this morning. I know we kept you waiting, or I kept you waiting a while.
It's no problem. Thank you.
Thank you, Ms. Jamel. You're free to go.
Okay.
Your Honor, we have nothing further on, or at least for Rob Jamel, I have nothing further.
Thank you.
And on behalf of DAR, neither do we.
Okay. You all want to summarize?
Yes, sir.
Okay. All right, Mr. Cook.
Thank you. Dar, so I don't know if you have this or if that's helpful, but what I'm gonna tell you, and I have all of this.
That all along, and I've written all
Perfect,
over it.
good. Made notes. All right. So the 1989 trust, the trustee is DAR. The allowable investments include, it's very limited, and it does not allow interest, the investments in state or municipal bonds. Apparently, there's a judgment out there. Today was the first day we've ever seen it. We have been working in this matter for 6 months. And we've asked for all the records related to the trust, and it was never given to us. Not only was it never disclosed to Joe, Joe was an infant when I think this thing was signed. It was never provided to us. Of course, we didn't look in every county or every, whatever there was, but we were never provided with this information. And we've sat and had several meetings about it. It would have been helpful to know any judgments related to the trust. We've asked for that information. We haven't seen it in discovery. So that's a bit problematic.
Do you think that in order for me to make a fair judgment, I need to be able to see that judgment because doesn't it in fact modify the trust?
Well, it does modify. You know what, Judge, I'd like to answer that question fairly. Yes. But it goes to the point that the failure to disclose information related to this trust, that would have been super.
I'm going to attorney candor at this point.
Okay. Yeah, I said, yes, I think that would be appropriate for you to review it.
Okay.
The expert didn't review it, and my candor is, Judge, I'm saying, not allowed. I'm saying, I think that would be helpful for you to look at that and review it. But it also goes to the point that it wasn't disclosed to us, and it was meaningful. And it would have affected the presentation of this case. It would have affected the discussions related to the investments. And because material facts have to be disclosed. And what that means is a material fact is a fact that needs to be disclosed so that the beneficiary can protect their interests. We would have liked to have known this 6 months ago.
No, I understand your predicament. I do.
Yes.
And I understand the rule of evidence that you've invoked. I do. But if the trust has been judicially modified, then what we're talking about right now is not the trust that's really before us. I have to, I don't know how I can come to an answer that potentially could be a wrong answer if the trust were modified in such a way that my judgment would countermand another judgment, or my judgment would be deficient in the information. I mean, so I'm arriving at a judgment potentially, if I were to rule in your favor, that would be quite easily appealed. So do we want to avoid an appeal
And
if,
Judge,
and actually get into the evidence exactly what it is the court needs to consider so that we have, so whatever judgment I arrive at will at least be on a sound bedrock, whether or not my judgment's correct, the bedrock of it would at least be correct.
and I began my response with yes.
I know, but we haven't admitted it yet.
And Judge, yes. Yes. Yes, Judge, I'm going to withdraw my objection and allow you to, I mean, not allow, but allow that to be a part of the evidence to consider it. I think it's fair.
Yes, and your point again is very well taken, that discovery that is requested properly and not provided properly should be excluded. Your point is correct in the law and the rule
Well-
of evidence, but I appreciate the capitulation
Well,
because I think that in this case, I really do need a solid bedrock to base any decision on.
and I understand that. And again, in all candor, I understand it and appreciate that. And so that's why I'm saying yes.
Thank you.
But the point is I'm
admitted.
making is not only was I right on the exclusion, but the other issue too is that this was never disclosed to us. We've been involved, may I finish? This
No,
was never,
I
disclosed
hear
to you.
you, and I don't think you're wrong.
and this, a material fact has to be disclosed. Material fact is a fact that's going to affect the interest of the beneficiary. This would have affected the interest of the beneficiary 6 months ago. And the failure to provide this information to us timely is a material breach. It is a material fact that should have been disclosed. This is just one extra
I'm-
issue related to the breach.
And I am not making any commentary on that at all. I'm just suggesting that a judicial modification is so vital to a proper decision. It would be different if this were evidence that were of any other nature.
I understand.
Okay.
So I'd like to continue.
Can we wait until Mr. Cook has finished his remarks?
Oh, I apologize. I thought you were just asking the question. I didn't realize he had started his
I was
closing.
really kind of just in a dialogue here.
Oh, I apologize. I just,
No, no,
I
that's
will
okay.
clear it up what I need to say in my.
Thank you very much. I appreciate it.
No, I
Mr. Cook.
apologize. I didn't realize he had started.
That's okay.
So the fact that, the other issue is too, is the fact that the expert didn't even have access to this. There's several reasons why the expert's opinion was flawed. It was flawed because he didn't have this information. And so that's another issue with respect to this whole trial. There's still a duty to render statements annual under that instrument.
Mhm.
And the duty says to render statements not less often than annually of the assets and liabilities of the receipts and disbursements. They admitted they never provided, and this is the one that Dart, they admitted they didn't provide these annual statements. And so that would be a breach again of the fiduciary duty. The other issue is, so the duties, what we have to show is that there's remedies for breaches of trust that have occurred and that might occur. And as far as we know it, I haven't even had a chance to review this. Of this one trust, the trustee had a duty to diversify the assets. There was nothing that excused him from doing so.
I'm sorry. And on that point, I didn't hear about what the damages may or may not have been. Can you remind me what the testimony was with respect to damages? Because isn't that an element of breach of fiduciary duty?
It is an element of breach of fiduciary.
What are the
duty.
damages?
The damages are the failure to properly diversify the assets.
Okay,
I mean, which was our argument.
that's a calculable damage.
That is a calculable damage, yes.
All right, thank you.
All right. I'm a little bit confused on this trust because I don't know where to go at this point. Because I don't even know what that agreed final judgment says.
Sometimes when, and I hate to do this, but sometimes when new evidence is admitted, perhaps we should take a pause and come back and read and examine it further.
I would like to do that. And I know that we're at a 12:30.
Yes. Yes, we are. And so are you seeking a continuance of this hearing?
John, I would ask for a continuance of this so I can consider this new evidence and be able to close and make arguments related to what
I
the.
think the court would like to also examine this new evidence because I do think it's important. And I have not read the judgment. I have no idea what import it has with regard to any of the trusts. I haven't looked at it, but it seems to me important. It seems to bear on the very definition of the trust, I assume. I don't know. And I don't know that I can render a decision today unless I have full information and the evidence has just now been admitted. I hate to do this, but it's important. What are your inputs?
I have no objection. I would like to make a comment about this judgment just a minute before we break today.
Absolutely. I think we're at a stopping here in Mr. Cook's closing. So if you'd like to make a point.
So this, as I understand, this judgment relates to only the 1989 trust, the very old trust.
Right.
I learned of this judgment within the last hour. The reason I learned of this judgment, which my client is not the trustee of, I want you to understand that this would not be within his
No.
purview.
Mhm.
But, you know, to the extent I want you to understand that Mr. Jamel leaned over to me and said, there was actually a judgment revising this trust to include bonds because they didn't mean to include state bonds.
Right.
And that's when we went and found the judgment during this hearing today. So this was not an intention to hide anything. I
Thank
think
you.
part of the problem is I understand what Mr. Cook, and I'm not discounting what Mr. Cook knows, but the problem is we don't know what his client knows. He hasn't been here. He hasn't raised his hand. He hasn't testified. So we're in the kind of guessing of Mr. Cook's trying to get things from a individual that of course people on this side have concerns about his abilities. And so I just offer, make sure you're aware at least, and I believe the same for counsel, nobody hid this. It's just the realities of scrambling and not realizing it existed.
No,
And I'm glad to put myself under oath and tell you, I didn't know about this. And Mr. Jamel, because he knew about it, but wasn't the trustee, leaned over and told me. And you probably saw that.
Your Honor, I apologize to Mr. Cook and Ms. Pacheco and the parties. This is our omission. Darge Mail has not been physically present ever in our office. We've communicated with him by telephone and various computer, Zoom and stuff like that. I learned about this judgment when Ms. Pacheco did. I had no idea. I think it would have simplified the presentation, and I'm sorry about our discovery responses not being timely. So the court will know about that. They were sent to us on a holiday weekend, late on the Friday of that, just before midnight. And they were calendared inappropriately. I apologize.
Thank you.
I've been a lawyer 52 years.
Mhm.
This is the first time that's ever happened. And I hope it's the last.
These things happen, and not to have had this occur in 52 years is an extraordinary record. And I do see this from time to time. Thank you for your explanation. I appreciate that. I think that there's no harm, no foul now that it has been admitted anyway. So I think we're good there, but
I don't think it affects my client's trust, but I wanted
I think
this
that
suggestion that we had hit it. I just feel like it's important to clear up because candor to the bench is one of the
Thank
things
you.
we all strive to.
thank you.
And so if we had done that, I would have accepted that responsibility. That's not what happened.
I accept that no one knew about this.
Well,
It changes the reality.
There's other attorneys, very fine attorneys have been involved for a long time
Well-
prior to their engagement. And we still didn't see it at that point.
Well, I don't know what the history is, and that's what happens with old trusts. This is not the first time. It doesn't change the landscape of my client's three trust, and I think that is out there. Whenever you want to reconvene for final argument, I will do my best to be
Well, I think
there.
we reopen evidence is what we do.
Whatever you
I,
wanna
I mean, my offer to you is what Mr. Cook is asking for a continuance to evaluate new evidence that he has only just received and has only just been admitted into court. I think it's fair. And in an important matter like this, I think that the court needs to have, you all need to have an opportunity to explain this to the court and how it interrelates. And perhaps you'll go away and decide to settle this without having to come back. I don't know the answer to that because I don't know how this affects anything. I take it at face value. None of you knew about this until very recently. That is
And I'm
the
to the
case.
court's point, however the court wants to handle it. I don't know if it changes anything other than the four corners of the document compared to the facts you've
I
heard.
don't know.
But that's not for me to say today. You tell it, whatever the court's gonna do at this hearing,
know.
we're,
If you-
we're gonna be available as needed.
Oh, okay. And
I will say I'm starting a trial in,
you're starting.
2 weeks in, Presidio County. So I just would offer that it's gonna be I'll have a window before, if that's Mr. Cook and your decision, and then a window after Labor Day.
And I will say, I don't intend with this new evidence to open the evidence and ask a bunch of questions related to this. I think I just need to review it, analyze it, and then make argument. So I just want to signpost that, let everybody know that I'm not going to call a bunch of people and ask.
Could we do it as quickly as this Friday or Monday coming up?
This Friday, I'm taking a deposition and
Okay.
out of town. I'm sorry.
That's okay. That's okay.
What did you offer
Or
next
Monday,
week?
Monday the 4th, which would be like at, again, 10:30-ish. Is that okay with you? Oh, sorry, we have a jury trial starting that day. Sorry, never mind. I can't do that. Never mind. But I think that jury trial will be over by Thursday or so. And it would Friday the 8th be something that we could do.
I could do Friday the 8th.
Friday the 8th, Mr. Cook,
Anytime on Friday.
Mr. McIntyre, Mr. Seidel.
I believe so.
Ready?
We will, yes.
Thank you. Why don't we set it for Friday morning, August 8th, 9 a.m.? Is that all right with everybody?
Perfect.
All right. I apologize. I know that you all want to get to a decision probably just as much as I do, but I think it's important that we all look at this new
Of course.
judgment and make a determination. Unless you all want to say that it has no bearing on it, then I can render a decision later.
I don't know what bearing it has.
Okay, very good. All right. Is there anything further then today? We're going to be adjourned until Friday, August 8th at 9 a.m. then.
Thank you for accommodating our schedule.
Thank you. I appreciate it. And
May I run?
you're dismissed. Enjoy your
Thank
deposition that you have coming up.